May it please the court. My name is Mahak Merchant, and I, along with my co-counsel Simon Pena, represent Sarah Parker Pauley, the respondent in today's case. This is a case about upholding the long-standing precedent set forth by this court in not allowing governmental aid to build up a singular religious entity.
In coming before the court today, it is our contention that to provide aid in this capacity to any non-secular or religious organization would be a direct violation of the Establishment Clause of the First Amendment of the United States Constitution. In order to prove this, there are two tests we will be applying. The first is the Lemon test, as established by Lemon v. Kurtzman. Under that test, there are 3 prongs to determine whether or not a governmental action violates the Establishment Clause of the First Amendment.
The first prong states that the action must have a secular purpose. The second prong states that the action's primary or principal effect must not advance nor inhibit religion. The third prong states that the action must not provide for excessive government entanglement with a religion or a religious institution.
If even one of these prongs are not met to its full extent, this court must rule that providing aid to the Trinity Lutheran Church would be a direct violation of the Establishment Clause.
Beginning with the first prong, the legislative action must have a secular purpose. The scrap material that would be provided free of charge to the Trinity Lutheran Church's Learning Center would be used directly to aid a religious institution. The respondent sees no way that providing this aid would serve any secular purpose whatsoever, therefore violating the First Amendment under the Lemon test.
Moving on to the second prong, the action's primary or principal effect must not be to advance nor inhibit religion. It is fairly obvious that in today's case, failure to provide extra assistance to a religious organization would not inhibit the practice of said religion. Inhibiting the practice of a religion would be a situation similar to that of the Church of Lukami Babalu I Inc. versus the City of Hialeah, in which the City of Hialeah directly infringed upon the rights of people to practice a specific religion by outlawing acts essential to the practice of that religion. Further, it cannot be stated that by providing direct aid to the Trinity Lutheran Church does not advance religion, as it provides for the Trinity Lutheran Learning Center to update its facilities, therefore looking more appealing to prospective parents and in effect advancing the religion that said learning center was based on. Therefore, the aid that the Trinity Lutheran Church is requesting violates the second requirement under the Lemon test.
Finally, the third prong states that the action must not provide for excessive government entanglement with a religious or a religious institution, essentially showing that the government has a compelling state interest in preventing entanglement with a religious institution. This prong is a simple one. Because of the religiously motivated portions of the curriculum, such as requirement of participation in religious prayer, it is obvious in applying the reasoning used in Abington County versus Shemp, that for the state to give this type of aid to not only a religiously motivated facility, but a facility that teaches scripture would be a direct violation of the Establishment Clause. Therefore, the aid that the Trinity Lutheran Church is requesting violates the third prong of the Lemon test. Therefore, Your Honor, while it is only required for the court to find that one of these prongs is violated in order to favor the respondent, we have proven all 3 of the prongs would be violated by the government providing this assistance to Trinity Lutheran Church.
The issue is not that the Trinity Lutheran Church is asking for help. It is that the Trinity Lutheran Church is asking for direct funds from the Department of Natural Resources to be given to a religious institution, which has been deemed unconstitutional. The only funds that are allowed to be given to religious institutions through the government are indirect funds, and even then, the funds must be designated by a neutral third party, such as a parent. This neutrality test was established in Zellman v. Simmons-Harris. It designates even-handedness when it comes to the issue of who may receive aid. This court ruled that direct aid to religious institutions for use in religious activities is unconstitutional. However, an indirect aid to a religious group through a third party, such as a parent, is constitutional, as they are the ultimate deciders of the final destination of the funds. In today's case, the funds provided to the Trinity Lutheran Church would be funds stemming directly from the federal government, in that the funds would not be passing through a neutral third party before reaching the religious institution. The funds would flow directly from the government to the religious institution, essentially causing the government to have a direct relationship with that religious institution, and in effect having a direct relationship with the religion that is represented by said institution. Therefore, under the neutrality test set forth in this court by Zellman v. Simmons-Harris, this court must also rule in favor of the respondent.
Your Honor, we have proven that under the test set forth by this court in Lemon v. Kurtzman and the neutrality test set forth by this court in Zellman v. Simmons-Harris, it would be a direct violation of the Establishment Clause of the First Amendment of the United States Constitution to allow the Missouri Department of Natural Resources to provide aid to the Trinity Lutheran Church and all of its subsidiaries in this capacity. We respectfully pray that this court rule in favor of the respondent. Sarah Parker Polly. Thank you.